is I think it was Mr. Cockrell who made a very important point, and I think he's correct on the face of it, that res judicata is an essential component of the rule of law. Would we be able to go that far to say it's in the interest of justice, notwithstanding res judicata finding to consider the matter?
Yes, in fact, I think it was in Mr. Cockrell's argument where I think it struck me that there is a conflation of two concepts. The one is the correctness of the 2020 order and whether or not you are bound by it. Now, on Mutsila, you are not bound by it. You can correct it. So if you're correcting it because it's legally wrong, you can correct the judgment. There's a separate issue about res judicata, which is whether it's binding, despite its legal imperfections or legal flaws, whether it's binding on the...
Before we go to the second one, I'm sorry to interrupt you, just on Mutsila. You see, in Mutsila, we dealt with a case before us, but it came very clear unanimously to all of us that Guarnieri was wrongly decided. And obviously one of the parties, I think it was the pension fund, the pension adjudicator, relied heavily on that judgment of the SCA. And in the course of that, we came to the conclusion that we had to make a pertinent finding that that case was wrongly decided. But what the banks argue here is that you can't then say as an applicant, well, because you had set aside a judgment in the course of deciding a case, an SCA judgment, you can now help us in this res judicata argument. They say you can't go that far. Mutsila isn't authority for that.
Yes, I understand that, and that's probably why I'm trying to draw a distinction between whether you are entitled to correct a wrong decision that is not on appeal. Mutsila is authority that you can correct a wrong decision even if it's not on appeal. So that would apply equally with the 2020 order. You can correct it even if it's not on appeal. That seems then, and again I'm drawing from the analysis of Mr. Cockrell, to leave out the question of res judicata, which is a separate issue altogether. And that is whether or not the Commission is nevertheless bound by the wrong judgment of 2020. And that is where res judicata operates. It doesn't operate to bar this court from correcting a wrong judgment. The problem here is that where the interests of justice fit in, it would be an artificial outcome, especially because of where we are in the trial. We are at the beginning of the trial, right at the beginning. It would be an artificial outcome to deprive the Commission of the benefits of the correction of the 2020 judgment, because there is no prejudice to that at all. And so it would be in the interest of justice in this unique case to then relax the consequences of res judicata if you have corrected the incorrect judgment based on Mutsila.
The last one on a different topic is Section 3.1.
Yes.
If we uphold your primary argument on Section 3.1, there are some of the banks that argue very vigorously. They argue that would give you, as I understand it, and they'll forgive me if I overstate their submission. They say that will give you extraordinarily wide jurisdiction. And the suggestion, as I understand it, and again I may have misunderstood it, the suggestion is that it is it's unique in the world to have that kind of extraterritorial jurisdiction. Now I speak as one with little experience in competition law. Is that a sound submission to make?
Certainly not in competition law. I think for the reasons that Justice Rogers pointed out, basically the reasons of comity, which in fact is probably the most useful lens through which to look at personal jurisdiction, especially because of the interconnected nature of the economies. I know that in the last 3 days we've been talking about cartels, but you can expand the framework of imagination to include Section 8, abuse of dominance cases, Facebook, Google, that are all operating in all markets, but located in the tax havens of Jersey. But the impact of their decisions is actually significant in all markets. And look at the approaches that have been taken in Europe and in America, where they have exercised extraterritorial power in order to prevent economic abuse and sometimes abuse of dominance. So once you take an unduly restrictive approach to jurisdiction in relation to cartels, you must remember that it will permeate across the entire scope of the Act. So I'm afraid to say it's actually an unsound approach to take in competition cases.
Thank you, Mr. Ngcukaitobi. Thank you, GCJ.
Mr. Ngcukaitobi, still on the question of Pickfords and initiation. One or two of the respondent banks complained about the fact that they were added at a later stage and they were never afforded. There was no initiation stage, no investigation. They found themselves being added in the 2020 referral. And that's the complaint that ordinarily there are 3 stages. You start it with initiation, you go to investigation, then the referral. I know Ms. Kalala said the initiation was, insofar as conduct, the prohibited conduct was concerned. But they are saying over and above that, the firms should have been, something should have been done. What is your response to that?
Yes, Justice Mhlantla, this is an academic discussion in the context of this case because it has no bearing at all. There is a discussion at paragraph 145 of the judgment, but it is a discussion with no end, no conclusion, no finding. When you are trying to work out what was the basis on which these banks were excluded, was it initiation or was it the breach of the 2020 order? That is decisively answered by paragraph 37 and 184. The reason why these banks were let off the hook, let's call it like that for lack of a better word, is because the judge found that we had violated the 2020 order. So the only debate before this court is whether it is correct that we violated that order. If we did not violate that order, then there is no issue that arises for discussion on initiation. That's the first thing. So that's why it is an interesting discussion, but it is entirely academic. When it comes to initiation, Ms. Kalala made 2 submissions. One is based on Pickford's initiate against an entire prohibited practice. The second one, which seems to have been overlooked, is tacit initiation, which comes also, Pickford's reinforces that it comes from Woodlands, which is initiation is an informal process. You don't even have to issue any document. The question is whether in April 2015, there was no tacit initiation in relation to every other participant to this cartel. And if there is one bank that can simply never complain about tacit initiation, it's Standard Americas, because the initiation was against Standard New York Securities. And if you are trying to work out what was in the mind of the commissioner when she initiated the proceedings in 2015 in order to figure out this debate about tacit initiation, it is impossible that she thought she can initiate and exclude certain banks that were in the SOC. She was initiating tacitly against those that she knew, but against everyone, even those that she didn't know.
What happens when you get information during the process of investigation, get further information that other banks or parties are implicated? What is the normal procedure? What would be done by the commission?
Yes. Well, there are 2 approaches to it. The one is Pickford's, which is what we dealt with here 3 years or 4 years ago, which is they just get added to the document. So you've got a long document with 25 possible respondents, you put a 26th and say, I've just found your name, you add. But you don't now go and start a new initiation. You just add them to the existing initiation because that's the name you have found. In this particular case, the most useful thing to do was to add them to the referral because already in April 2015, you had initiated against the practice and you named those you didn't know, and then you found out others. And then the only debate is about prejudice. It's actually a height of artificiality, this idea that every time you find a new respondent, go and initiate afresh, because what it does is then you run parallel proceedings because you're already in the trial, you're already prosecuting against certain banks. You find out, actually, I was wrong, there are 3 more. According to them, start afresh and run another trial on those facts. Now, that just makes no sense, which is why the correct interpretation is that actually you would be allowed to add them at the stage of the referral, even though they are not named in the initiation, because you must take the initiation to be a tacit initiation against the participants, named and unnamed.
In Pickford, there were 2 initiations.
Yes.
The original one is 2010, where Pickford was not mentioned.
Yes,
And then when you got to know about Pickford, you had a second one in 2011.
precisely.
So you're saying you don't necessarily have to do that all the time?
No, it would be impossible. I mean, if you have referred, so you already referred in February 2017. It's already, what you are doing now, you are amending your referral because there are exceptions. And then one of the banks settles with you. They give you their data set, including chat rooms and trading data. Say, here it is. And then they say to you, look at the following trends. That bank, NetBank, is part of us. Unfortunately, you didn't know about them at the beginning, but they are part of us. In that instance, you would be allowed to include them in the referral because your April 2015 initiation must be taken to be a tacit initiation against every participant who bears the similar characteristics of that conduct.
Some respondents, I can't recall now which one, they complained about.
You are not alone, Justice.
They were dragged in respect of one single chat or a chat that lasted a few minutes. Can you perhaps say something about that?
Yes. What is important there, we accept there are 2 banks where there's one chat. We accept that entirely. But what is crucial there is not the number of chats. It's not the number of chats. What is crucial is the nature of the information and the counterparty to see whether it comports with the general trend of the SOC. So why are you talking to Katz about a bid offer spread? Why are you talking to Ayer about a bid offer spread? Why are you talking to Cummins about a bid offer spread? Why are you talking to Williams? Why are you talking to Howes? These are the kingpins. These are the criminals. These are the kingpins. So once you have that, it's sufficient to connect you to the broader SOC. The other theoretical postulation that we saw here is that what about the theoretical possibility that it's small cartels elsewhere? But that was roundly rejected by the tribunal as a possibility. Then the other one is, what about bilateral conversations? These are all impossibles because it's clear that there is a trading happening at a central and at a central level, and it's 2 currencies. And in order for the strategies to work according to the referral, in order for the strategies to work, for the profits to be made, it needs a multilateral character. So you can dismiss all of those as fanciful at this stage and not supported by the referral.
DCJ.
Mr. Ngcukaitobi?
Yes.
Can you elaborate on the kind of powers and discretion that the tribunal has? And if I'm wrong in saying that it has a discretion, explain to me what the powers of the tribunal are, and under what circumstances can the CAC disturb their findings. This question is in relation to the fact that in a lot of these cases, the CAC overruled the tribunal. And I'm interested to know whether it was proper or it was correct in doing so. And that will then be determined by what kind of discretion, if any, does the tribunal has.
Yes. Thank you, Justice Shirko. That's actually a very, very important question. I think most of us have overlooked. I think there are 3 categories of decisions that the tribunal will typically make. So there's one, legal decisions, where it's analyzing the meaning of an act. Now, we would accept there that the Competition Appeal Court is entitled to intervene and correct them if they are wrong. And that's not a discretionary issue altogether. The second is where it's evaluating facts. It's deciding on the facts. That issue is decided in the case of this court called Mediclinic, that there is a level of institutional autonomy that the tribunal exercises as an expert forum, and that's different from specialist, as an expert forum because it comprises of economists and lawyers, unlike the CAC, which is a specialist but comprises only of lawyers but no economists. So that deference to expertise has been recognized by this court in Mediclinic, that when it comes to evaluation of facts, the Competition Appeal Court will only interfere where basically they were smoking their socks. Then you have a third category, which is discretionary decisions. In that third category, you will fit there a decision as to joinder. Joinder of necessity, joinder of convenience. There, it's purely discretionary, or decisions about postponements, or decisions about condonation, etc. These are purely discretionary. You will then ask yourself whether or not the CAC has satisfied the standard rules for interference with discretionary decisions. Now, this is the problem we have here, is that basically what the CAC thought, it thought that it was the tribunal, it could redo the exercise entirely without any regard to what the tribunal said. Let's just do it the way we want. And that is very, very clear when it came to the joinder decision, because they never conducted an evaluation of the tribunal's reasoning to see whether it fits those patterns of appellate interference with discretionary decisions. So you've got two areas of constraint. One is factual evaluation, second is discretionary decision. And you've got one area of unrestrained interference, which is legal assessment.
Where you were at idiom that interests of justice have to be the determining factor. But what I'm asking is, what factors would we have to take in this matter to conclude that it is in the interest of justice to interfere?
Yes. Now, it's only if I am right in my primary submission that the CAC was wrong. If you say the CIC was right, fine, then there is no debate. But if they were wrong in CAC 2020, that is a factor that you are correcting a wrong decision. But it is also a factor that you are correcting a wrong decision in relation to jurisdiction. The second thing you will take into account is the stage at which the proceedings are at. This is right at the commencement of the proceedings. Then you will take into account prejudice. There is no prejudice in this case, and you know, I've heard a lot of things in this case. Everyone has a different rendition of what we said. Then they say, we've also distorted what we said. End up getting so confused. So on this point about lack of prejudice, you know, Justice Chief, in our pleading, I showed the court we relied on section 3.1. We also tried to comply because we thought we must comply. Otherwise, you know, we are an organ of state. But we also relied on section 3.1 independently from the connecting factors test. Before the CAC, we ran the argument that section 3.1 is decoupled from the common law. We know the consequences because the transcript is here. In this court, we ran the argument again. In 2020, we had run the argument. There is no one who can be prejudiced about this argument being raised here. No one. So we would say that those three factors would play an appreciable role in your assessment of where the interests of justice lie.
Thank you, Mr. Ngcukaitobi. Thank you, TCJ.
Mr. Ngcukaitobi, my question relates to Res Judicata, which you have touched on. In relation to the third respondent, do you accept that they may be prejudiced if we reopen the interpretation of Section 3.1 in this court, since they did not oppose the application on the basis of that point being raised, the Res Judicata initially?
Justice Saron, no. Why would they be prejudiced? Because you are correcting the law. How can anybody be prejudiced with the correction of the law? And all of the arguments that had to be made have been made. This is one case. It's not separate cases. They want to raise their own case. But that just doesn't make sense, because why would they want to raise their own argument in addition to what others have said? What's the unique thing they were going to say? So no, I'm afraid no, I don't accept it.
Would those respondents who were joined later, the additional banks, would their position be different in relation to the previous respondents in respect of the Res Judicata point?
And no, they can't be. Remember that we added Incola and Standard Americas. Yes, Standard Americas and Incola. Standard Americas is here. The rest are Incola. They are irrelevant to the debate anyway.
So you say they won't be affected,
Yes.
whether they were joined later or previously by the Res Judicata point issue?
No, it's irrelevant to the Incola. And also irrelevant, I would say, to the two categories of foreigners with presence in South Africa, because there is another basis to exercise jurisdiction. It's only relevant to the pure peregrine, but the pure peregrine have run all of their arguments here.
And I suppose whatever decision, if the court reaches a decision on the Res Judicata, it has to apply to all the in respect of all the respondents, whether they were joined before or later. And it shouldn't, if the court finds in favor of the respondents or some of the respondents, Res Judicata point, all the respondents should get the benefit of that.
Oh, no, I accept that, yes, entirely.
Yes. Thank you, Mr. Ngcukaitobi.
Yes. I'm told by my learned colleague that the point was raised in the application for leave to appeal to this court, so everyone had noticed. We noticed as well that, Justice Terod, there's actually quite a lot of parties that never took Res Judicata. They took preemption. Once they saw that the train was moving on the Res Judicata, they joined in. But anyway, I'm not going to complain. so.
Mr. Ngcukaitobi, first on the question of initiation, you say that the Competition Appeal Court only knocked out the case against the 24th to 28th respondents on the basis that the first judgment didn't allow further joinder, and therefore initiation is not before us.
Yes.
But if we take Standard Americas as an example, the actual order in CAC 2 was simply that its dismissal application is upheld, or its appeal is upheld, and its dismissal application is granted. The principle on appeal is that the successful party below, here the respondent in the appeal, Standard Americas, can defend the court below's order on any basis that could properly be raised. So that if there were 2 or 3 grounds on which it could have succeeded in the CAC, and the CAC only decided 1 ground, if that ground is wrong, Standard Americas can still say, but that order was still justified because we should have succeeded on the initiation point, which the CAC didn't consider. Yeah. Isn't that the correct procedural approach?
No, that's correct, but it doesn't apply here. Because I actually considered the question yesterday before raising this argument. The reason it doesn't apply is twofold. The first is that here we are not without, we are clear about what the basis for the order was. The basis for the order is set out under findings, paragraph 184. That's number one. The second thing is that an order as to initiation would have invalidated the referral. So they would have said the commission had no jurisdiction to issue the referral because it was barred from doing so because of the absence of the jurisdictional fact. That order was not made. So we are not in a stage where your referral has been set aside, but we don't know the basis on which it has been set aside, and therefore you can defend it on any basis. The stage at which we are is it's the order of the tribunal on joinder that has been set aside. And it's been set aside on one basis, which is the absence of the incorrect interpretation of the 2020 order.
As a matter of form, that doesn't seem to be right because, and this is perhaps an illogicality in the CAC 2 judgment, that, you'll say the only one, they didn't actually say that the the joinder application for Standard Americas is dismissed, which might have been the logical conclusion of its reasoning. They actually said its dismissal application was dismissed, was upheld.
Was granted, yes.
Yes. So it didn't. The CAC didn't actually make an order on the joinder application. It made an order on the dismissal application. And what we have before us is whether the CAC was right to have held that the complaint against SAI, its objection to being a party to these proceedings, should be upheld. And I still don't see why it makes a difference. If the CAC in this case had said, reasoned, this is the meaning of the first judgment, it doesn't permit further joinder. If it had then added, for this reason, we don't need to consider the initiation argument. I'm still not certain, but perhaps you feel you can't say anything more on it, but I still don't understand why they can't, before us, say that even if the CAC was wrong on its joinder reasoning, we are still entitled to support that order on the basis of our initiation reasoning.
No, I think that the difference, Justice Rogers, is really this. Upholding an initiation means setting aside the referral against Standard Americas. That's the only logical way of upholding the initiation point.
Well, I don't think Standard America says we must set aside an initiation. It says we can't be part of this case because there wasn't an initiation at all against us.
No, setting aside in relation to them. I think we're talking about the same thing.
No, well, it would be setting aside potentially the referral against them.
Yeah, sorry, the referral in relation to them, yes. Now, that's the order we would have needed to constitute the jurisdictional fact to debate on appeal, that the initiation has been upheld. And we don't have to speculate here because after everything he has said, he then has a different section called findings. And in that section that is called findings, he says, I'm going to set aside, if you look at paragraph 184, I'm going to set aside the joinder finding because you were prohibited by my 2020 order. So this is made clear in the judgment. The discussion in paragraph 145 is not followed by any consequential relief. And in fact, it's not even conclusory because he says, I'm skeptical about your argument, but he never actually reaches a conclusion on it. It's only 184, and then you read that together with the order. And you apply the standard ways of interpretation of the judgment.
But it seems to me your approach, you don't like Stalingrad, and I think nobody likes Stalingrad. Certainly the court wouldn't like it. But this leaves now for another day, which a fight by Standard Americas on its initiation and joinder point, because you say that hasn't been decided yet. And we can't deal with it because it hasn't yet been decided. All we can do is say that the CAC was wrong in regard to the effect of CAC 1. But that means a point which may be right or may be wrong hasn't yet been decided. Standard Americas is entitled to an answer on it. And if it can't get it here, it will have to get it in some future proceedings before the tribunal.
Yes, well, I suppose you could take that into account in the assessment of what is just and equitable as part of your Section 172 power. And then say, as part of our 172 power, which is a very broad power, one of the factors we'll take into account in deciding to decide the initiation point is exactly the kind of consideration that you're putting to me. But as a matter of law, what you cannot do is to conflate that finding that was made into a finding on jurisdiction in relation to the referral, because the judgment makes that beyond any contestation. If we are in Section 172, which I understand is a possibility to say, look, judicial economy, interests of justice, we must decide everything, including those issues that have not been decided. Yes, then I accept that you have the power to do that. Has Section 172 been invoked here as a basis on which you can decide that? The answer is no. Do you have mero motu powers to invoke it? Yes. If you are at that level, we have made the submissions about the tacit nature of the initiation against all of the participants to this currency fixing.
Thank you. My other question relates to res judicata. You said in response to a question from one of my colleagues that, firstly, this court can say and can correct CAC 1 on the law.
Yes.
Secondly, it then must consider whether, nevertheless, by virtue of res judicata, it remains binding between the parties in this litigation. It seems to me that in principle, not specifically in this case, but as a general matter of law, that puts it the wrong way round. The first question should be, is this point res judicata? If it is not, we can address the point of law. If it is res judicata, the whole point of res judicata is to take it off the table, to mean we shouldn't decide it. We can't decide it in this case. Now, I accept, of course, that this court can, when a judgment of the Competition Appeal Court is quoted to us as a precedent in relation to a matter that is properly before us, we can overrule any CAC judgment and say it was wrong. But it first has to be germane to an issue it is proper for us to decide. And to decide whether your Section 3(1) argument is right or wrong, is properly before us, we must first decide whether it is res judicata. At most, if we found it was res judicata and that there weren't grounds for departing from res judicata, we might say we leave open the question whether CAC 1 was right in this respect. But it seems to me it would be improper for a court that has found an issue to be res judicata to nevertheless say that that point was wrong or right. It would be, apart from anything else, it would be an obiter dictum, because it wouldn't be necessary for the decision in this case.
I think, Justice Rogers, we are debating the form in which the judgment should take. I am submitting that what is appropriate is that you must first decide whether 2020 CAC was correctly decided. And that is a separate issue from whether or not the doctrine of res judicata applies.
For what purpose for resolving what issue that is properly before us, must we decide whether CAC 1 was right or wrong?
Well,
What is the relevant issue?
well, there's only one issue on that score, is Section 3(1), which you've identified.
Yes. So in order to say that we must decide whether CAC 1 was right or wrong, we have to find that the proper interpretation of Section 3(1) is properly before us.
Yes, correct.
We can only answer that question by first determining whether that issue is already res judicata.
No, I see your point. Then no, we don't accept that, because that's putting the cart before the horse, because you cannot use the doctrine of res judicata to interpret the correctness of a judgment. You use the doctrine of res judicata to decide whether or not I am bound, but not to decide correctness. Correctness is a separate inquiry.
I think in due course we might need to decide whether we prefer your horse to mine.
or your horse. No, I think that's the other way around, but I see the argument that the way you are framing it is, let's start with res judicata and then go to correctness. Yes. My framing is start with correctness and then goes to res judicata.
On the question of departing from res judicata, you correctly mentioned that prejudice would be one factor.
Yes.
Not the only one, and not necessarily decisive. Now, I recall that some of the respondents have raised, but in any event it's inherent in the case, that following CAC 1, there was 3.5 years of litigation based on the footing that CAC 1 had laid down the ground rules for the future conduct of this case. Inter alia, on the strength of that, the Commission filed a superseding referral affidavit. That affidavit had to be examined by all of the respondents, They then filed, and there are probably 14, 15, 16 dismissal applications and exceptions. There are joinder applications. All of that, your client filed answering papers, there were replies. The matter was then argued, I can't recall over how many days in the tribunal, probably 3 or 4. It was argued over 4 days, if I recall correctly, in the Competition Appeal Court. All of this happened on the basis that the parties were testing whether what you had done in your superseding referral affidavit complied with CAC 1, including qualified effects and adequate connecting factors. All of that is wasted effort and wasted costs. Wasted time, wasted effort, wasted costs, if we can now throw CAC 1 out and say it isn't binding between these parties. Isn't that relevant prejudice?
No, not in this case, because they would have had to defend themselves anyway. And the fact that one of the grounds on which they would have had to defend themselves is the issue of jurisdiction. They always had to raise jurisdiction because they always disputed that there were adequate connecting factors. There is no extra cost that comes from a different slant to Section 3.1.
But if the argument was that everything turned only on some effect and that the involvement of the RAND constituted that effect, if that point had been appealed and had been upheld by us, we had accepted your 3.1 argument in an appeal against CAC 1, none of the parties would have taken or could have taken any of the objections which occupied a lot of the time against absence of adequate connecting factors, absence of proper pleading of qualified effects. There would still have been objections about whether there were sufficient facts to show that a particular bank had joined the conspiracy or not. But a lot of this case would have been rendered redundant by a timely appeal against CAC 1.
I'm skeptical, Justice Rogers, and I say this in all seriousness. I'm skeptical about that assumption because even a Section 3.1 pure argument was still met with an objection based on effect throughout in this trial, this particular case that we're dealing with.
In round 2, it was
Round 2, yes.
yes, but that was on the basis of were there foreseeable, direct, and substantial effects.
Yes.
In other words, qualified effects.
Yes.
Your argument is that that isn't the test. If we had upheld in an appeal against CAC 1 your argument that any effect whatsoever suffices, then that line of attack would not have been open to any of the banks.
No, I mean, we still accept effects, but obviously not qualified effects. But because the section itself says effects. Yes. So, yes, that is possibly true that some of the banks could have reconsidered their position. But I am skeptical, having lived this case for 7 years, that that assumption is correct. I think that we would have still been met with jurisdictional objections. I still think, even if you directed them to go back and plead over, I think there is still 1 or 2 objections coming. So I'm not as confident as you are, I'm afraid to say.
No, I was raising it as to whether it's not prejudice. I've heard your answer. Thank you.
Okay, thank you, Justice Roger.
I think we've reached that point. We've gone past it, actually. But Justice Matopa has a question. Justice Matopa?
Mr. Ngcukaitobi,
It's just,
this issue about jurisdiction troubles me a lot. For the simple reason that if it is against, it's decided against you, what are the possible scenarios available to the competition commission? I'm taking a more practical view, a holistic view about what this case is all about, and asking myself, you did not take the point at CAC 1. This is the debate that I had with Mr. Loxon on the implications, the nature and effect and implications of this plea of res judicata.
we took it in CAC 1.
Yeah, I must say it troubles me.
Yes.
1 and 2,
Okay.
whether you should have appealed or did not appeal, and because you did not appeal, you are precluded, you cannot raise it before us now. and now you're saying it's a matter of law, it's a point of law, you are competent to raise it, but you are met with a plea that says you can't. If you had to raise it, the option was to raise it back then, you can't raise it now.
Yes.
And you're saying to meet with that objection, you would say we should relax it on the basis of the interest of justice. Did I understand you correctly there?
Yes, I have had to embrace that alternative argument, despite myself, because my primary argument was that it's irrelevant, because I'm raising an interpretation of Section 3.1 of the Act. And that's a question of the correctness of the 2020 order, which you have the authority to decide as per Mutsila. That's the primary argument I had raised. And you are not bound by what they decided. You must decide what the law is. Then,
Oh, sorry, I was trying to look at Mutsila, the relevant paragraph. I know I was on the panel, yeah, but I've forgotten what it says. Can you just quote the paragraph?
let's ask Justice Teron.
No.
Sorry, Judge, I don't actually have it.
I have the judgment with me here.
So I don't have it. I'm going to try to make sure we get it. What is the paragraph?
Because I just want to know what we said there in Mutsila, which you are embracing.
Yes, I'm told Justice Matopo is 100,
I'm at 100.
101, 102, and 103. So the actual finding is 103.
So embracing Mutsila, you would argue that in 103, we should borrow from what we said in 103 to apply pari passu in this case as well.
Yes, yes. On the correctness issue, not on the res judicata issue, yes.
I'm now worried about precedent, stare decisis.
Well, you have it, Mutsila.
If this is what we said in Mutsila, and we are urged to say something different in this case, and we may take the flag of inconsistencies with our judgments, unless if your reading of Mutsila, I still have to apply my mind. Unless if your reading of Mutsila, it's not opposite. It can be said to be distinguishable.
Yes, I mean, there, legal reasoning is an elastic thing. But you could say that this case, we have to decide res judicata first, and therefore we don't engage Mutsila at all. And that is a point of distinction. But again, in this elasticity of legal reasoning, you could also say that the correctness as to jurisdiction is such a fundamental issue, which is what has been cited here from cases like May's Board. And you will not allow a jurisdictional finding to stand, because that will perpetuate a legal wrong inconsistent with the statute. And you take it as a matter of principle and decide, and Mutsila would be good authority for that.
I need to think about this. But as you know, as you may have been aware over the days, it has been a source of concern for me.
Yes, no, I appreciate
I don't have the answer yet. Yes. I have listened to the forceful argument by Mr. Loxton on the point, and Mr. Cockrell as well, and your equally persuasive argument on this.
Well, I hope I'm the only one who's persuasive. Thank you, Justice Mutopo.
We will. Is there a question? Okay.
Toby, just one question from my side. You've urged us in embracing the idea that there was a single overarching conspiracy to conclude that the only reasonable inference to be drawn is that all of the respondents were part of that conspiracy.
Yes.
You don't suggest that there were bilateral agreements, but if they were part of a conspiracy. Or,
Yes.
and as I understand your argument, your suggestion is that if two traders were in a chat and the chat evidenced conduct of fixing,
Yes.
then the fact that the other trader was in other chats
Yes.
would be sufficient to draw the inference that this trader who was in a single chat was part of a conspiracy, correct?
Indeed, indeed. Thank you.
Now, just arising from that, when I look at the referral affidavit, and the referral affidavit deals with the direct, immediate, and substantial effect test, even though you don't primarily rely on that test, you rely on the effects test, correct?
Yes. Yes.
Now, under that section, there are two sort of subheadings, and the one deals with foreseeability, and the other deals with the cumulative effect.
Yes.
The tenor in both those sections speaks of both the period of time
Yes.
and persistence.
Yes.
So the suggestion is that time and persistence are in fact relevant considerations in the conclusion around foreseeability, around cumulative effects, and fits into that mode.
Yes.
When one then posits that against single conduct, for example, could it be said, well, there are two inferences that could be drawn. The one, that even the single conduct provided with somebody who's involved in other type of conduct may lend itself to the reasonable inference that you're part of the SOC.
Yes.
But another inference that could be equally reasonable could be that's an isolated incident. And the fact that you're associated with Mr. Ayer, for example, and if Ayer is involved in other chats, that may not be a reasonable inference under those circumstances, especially in the light of the assertion by the Commission that time and persistence would be a factor. How does one deal with time and persistence in the context of lending itself to a reasonable inference when it might militate against that?
Justice Kolopin, firstly, I accept that time and persistence are relevant. They are actually very strongly relevant. Yes. And I accept that instances of singular participation would also be relevant, but not decisive. And then if you are in that mode, you then have to look at other surrounding factors. And those surrounding factors then could be the nature of the collusion, the currency pair that is engaged, the counterparty to it. And then, bearing in mind what is said, and I'm very grateful that you've taken us to the effects section, because it's actually a strong section on knowledge. Bearing in mind what they knew, if you look at 275, the last sentence there about what they knew. The traders were aware of this when they engaged in the collusive conduct and posted quotes, or in some cases withheld quotes, on international trading platforms with the aim of manipulating the ZAR. So that's what they know. They know what the effect of what they're doing, even though they are purporting to be acting bilaterally. Then in 276,
Could I just interrupt you on that? Would you disagree that when you say the traders would have knew that that's a conclusion?
no, it's supported later if you look at 466, because I've also taken that note into account. Why did they know 278? The traders could see in real time the effect of their manipulation of the currency exchange and the lasting impact on the bid-ask spread. So they could see, as they were doing it, what was going on to the currency.
Sure.
It's not a conclusion without fact. It's a conclusion plus fact.
But is it not equally be contendable that even in a bilateral relationship they could see? And that doesn't necessarily lend itself to reasonable inference that they were part of a conspiracy. But I'm saying it could cut either way.
No, the problem with that is that it can't cut either way if you look at what they could see is the impact. Because if you look at what they could see is the impact, there's no reasonable way that a pure bilateral once-off chart could have these catastrophic impacts that are described in 275 to 279. So what they could see, which was going on in the global markets on the trading of the rand, is only consistent with knowledge of the conspiracy as a whole, completely inconsistent with knowledge only of that bilateral conversation. And the last thing on this point is just to refer the court to the findings of the tribunal at 132, paragraphs 132, I think these are in volume 2. Volume 2, volume 3. But in the judgment of the tribunal is 133, 134, 135. And then it goes on to 143. Because they examined this in detail, this question of what could be inferred from what was happening. And then it said, when you look at the entire picture, it is fanciful to think that these traders only knew that once-off chart. The actual realistic way of understanding this is as an integrated system of collusion. And interestingly, these findings are actually just not dealt with at all in the CAC finding.
Okay, thank you, Mr. Ngcukaitobi. Thank you very much.
Thank you, Mr. Chief Justice.
I don't think there are any further questions, so we're going to take our 15-minute tea break. And when we come back, we're going to deal with the cross appeal. See, Mr. Cochran is ready. Court adjourned.